Good afternoon. Welcome to this year's Irving R. Segal Lecture. I'm Ted Ruger, the Dean of the Law School. It's a great pleasure to introduce in a moment two distinguished speakers who will be joining us tonight. Each year this lecture brings together oral advocates from the highest levels of the profession and top lawyers to Penn Law. It's a fitting tribute to Irving Segal, who was a 1935 graduate of Penn and a 1938 graduate of the law school, and then a leading member of the bar here in Philadelphia at the Schneider, Harrison, Segal, and Lewis firm for many years. Mr. Segal was a tremendous courtroom advocate, and this lecture honors lawyers from around the country, even around the world over the years, who embody the best attributes of advocacy in very different settings. And certainly General Baker and Alka Pradhan, who you'll hear from tonight, work in front of the military tribunals in Guantanamo in one of the most kind of vivid and important oral advocacy or trial advocacy settings there are. I'm really proud to say this year marks the 32nd anniversary of the Segal lectureship. Over the years, we brought such distinguished and diverse speakers as F. Lee Bailey, Supreme Court Justice Lewis Powell, Ken Feinberg, the Special Master for the September 11th Victim Compensation Fund. I'm also pleased to recognize Dr. Kathy Segal, Buddy Segal's daughter, who is here with us tonight. Welcome. And this year, the topic of our Segal lecture is as timely, as important as ever, entitled Drinking from a Poisoned Chalice, post 9/11. We'll be hearing from two advocates really on the front lines of human rights law and justice, where national security and the rule of law intersect. We're honored to hear first tonight from Brigadier General John Baker, the Chief Defense Counsel of the U.S. Military Commission's Defense Organization. In this capacity, General Baker oversees a total staff drawn from across the branches of the military and civilian legal bar of more than 156 military and civilian lawyers, paralegals, investigators, intelligence analysts, defense security officers, translators, and administrative officers, providing the full spectrum of trial defense services to detainees at Guantanamo Bay, Cuba. Said in another pithier way, he's the military's top defense counsel at Gitmo. As many of you are aware, last fall General Baker made headlines in the wake of a fascinating development involving civilian lawyers, where he suddenly went from the role of defense counsel to defendant or detainee. General Baker allowed the team of civilian defense attorneys who were part of a team representing the alleged mastermind of the USS Cole bombing to quit the case after these lawyers accused the military of spying on privileged attorney-client communications. The judge in the case, Air Force Colonel Vance Spath, held General Baker in contempt of court for refusing to rescind the order letting the attorneys resign, while Baker argued he had the authority to do so. Spath sentenced Baker to receive 21 days of confinement at Guantanamo, a stunning and almost unprecedented move. A few days later, a Pentagon official issued a deferral, essentially letting the general go about his business, although, as he relayed to me in my office a few minutes ago, there's still a pending habeas corpus petition in the DC District Court, so this is a live case. This episode brings to the fore key issues in the ongoing debate about the existence of robust rule of law, including robust defense for the accused at Guantanamo, as well as basic issues of due process and public faith in our military commissions. And of course, these are among the subjects that General Baker will address when he speaks soon. General Baker has also served in his long and distinguished career as Deputy Director of the Judge Advocate Division for Military Justice and Community Development, also serving as the Marine Corps representative to the Department of Defense's Joint Service Committee on Military Justice. He served as the Chief Defense Counsel of the Marine Corps. Prior to attended that, he served in the military even before law school and attended the law school under a program supported by the military, as some of our current students in the room are, and earned his JD at the University of Pittsburgh School of Law, also an MBA from Everett University. and he also holds an LLM from the Judge Advocate General's Legal Center of the U.S. Army. General Baker is decorated and has received the Legion of Merit, Meritorious Service Medal, Joint Service Commendation Medal, and many other awards in his distinguished career. He is also, among the many awards he's won, he's also, I'm sure, just as proud to count as his brother, a Penn Law faculty member, Tom Baker. So, so there's a deep Penn Law connection here as well. We're really pleased and grateful, really, to have two speakers for our Segal lecture tonight, and two brilliant criminal defense lawyers. Our other special guest, along with General Baker, is Alka Pradhan, who's a noted criminal defense attorney, currently defending one of the accused 9/11 defendants currently held at Guantanamo, Ammar al-Baluchi. According to a recent profile in the New York Times, Pradhan's job is to, quote, to remind the tribunals and as much of the world as she can that her client is human, that he has rights, and that those rights have been violated during his time in detention. In addition to being a contract attorney with the U.S. Department of Defense, she's also a lecturer here at Penn Law. Alka Pradhan has long worked at the crossroads of international human rights and national security. She has previously served as counsel for the Constitution Project's Task Force on Detainee Treatment and has worked in private practice at White and Case. She's also acted as human rights consultant to the Asian African Legal Consultative Organization and the UN Human Rights Committee. She's a member of the American Society of International Law. She did attend Columbia Law School, we'll forgive her that, and also has an LLM in International Human Rights from the London School of Economics. So I couldn't be more grateful or prouder to bring these really two tremendous attorneys to speak with us today. And with no further ado, thank you, General Baker. I'll turn it over to you.
You know, I was nervous before I even got up here, but that made me a little more nervous. I'm going to do something I don't often do, and I'm going to speak from prepared remarks, so that is either going to work or it's not going to work. But Dean Ruger, thank you for the introduction. It really is a pleasure to be here at Penn, which has a rich tradition of molding and supporting defenders of the rule of law. Indeed, your Center for Ethics and the Rule of Law is dedicated to the preservation and promotion of the rule of law in the 21st century warfare and national security. It's also a humbling honor to be invited to give the annual Segal Lecture in Trial Advocacy. I didn't have the privilege of meeting Buddy Segal, but from all that I've read and heard, he had a long and distinguished career as a trial advocate who, by his actions, words, and deeds, helped shape the rule of law in civil practice for 60 years. Dr. Segal, I would like to thank you for all that your father has done for trial advocates throughout his career. Because Buddy Segal was such a strong believer in the American system of justice, I'm afraid that he would be very disappointed to hear some of what I am about to talk about. But I am certain that he, like I am, would be very proud of the trial advocates carrying out this important work. Before I go any further, let me confess to being a little nervous. As a starter, after looking at the list, and I didn't even get the list with the Supreme Court justice. And I watched some of the talks on YouTube. I'm that much of a nervous Nelly that I had to see what other people talked about. But I do know that the bar for this lecture is really high. Secondly, I'm nervous because I'm talking in front of my older brother. And third, the real reason why I'm nervous is that I struggled a bit with trying to figure out what to talk to you all about. I wanted to keep to the main topic of trial advocacy, while I also wanted to introduce you to the Alice in Wonderland through the looking glass world of the Guantanamo Bay military commissions. In the end, after I talked to Alka and Mary, I decided that I should focus my remarks primarily on the military commissions. And through that discussion, I hope that you will see why trial advocates and lawyering matter, particularly down at Guantanamo Bay. And I'll do more than just tell you about the trial advocates this afternoon. After I've finished my remarks, I will introduce you and turn the floor over to Ms. Alka Pradhan, who you heard is the human rights lawyer, and she is a fierce trial advocate for Ammar al-Baluchi, one of the 9/11 co-accused who's facing the death penalty down at Guantanamo. This patriot is better known to many of you here at Penn as Professor Pradhan. I also have with me Ms. Mary Spears. Mary is the general counsel for our organization. Until about 6 months ago, she was a defense counsel. She was one of the three that I allowed to be excused from the al-Nashiri case. Mary's going to be available afterwards. There's a reception. She'll be at the dinner as well. All right, so let's get started. As you heard from Dean Ruger, I am a career Marine. My background is primarily in military justice with pretty significant experience in 3 important seats in any courtroom. I've been a defense counsel, I've been a prosecutor, and I've been a judge. Before my current assignment, I could not conceive of some of the extraordinary legal events so perilous to the rule of law that I've seen unfold down at Guantanamo Bay. You might expect that I'm going to talk about certain things today. You might think that I'll describe the military commissions and their history in the United States, or how the military commissions compare to the court-martial system or the federal court system. But I'm not going to do that. Indeed, I can't, because the Guantanamo Bay military commissions aren't a natural evolution of acceptable jurisprudence, and they don't conform to what we consider the normative standards of justice. Instead, I'm going to call it as I see it this afternoon. And to be clear, these views are mine, and they're mine alone. They don't reflect the views of the Department of Defense, the United States government, or any agency or instrumentality thereof. For just about the last 3 years, I have been privileged to lead an organization called the Military Commissions Defense Organization, or the MCDOE, as we call it. The MCDOE's mission is to provide ethical, zealous, independent, client-based defense services under the Military Commissions Act in order to defend the rule of law and maintain public confidence in the nation's commitment to equal justice under the law. Put more plainly, the MCDOE defends the rule of law in a military commissions system that is flawed in both design and execution. As the Chief Defense Counsel, I don't represent any accused. In fact, I don't stand up in court except when the judge held me in confinement or in contempt. Instead, I supervise the defense teams that represent their individual clients. I see myself primarily as their protector and their advocate. I watch them in court, I fight to get them resources, and I listen when they want to discuss things. But to be clear, the teams make their own litigation decisions. One of the advantages of my position is I get to see all the teams in all the cases, which gives me a bird's eye view of the military commissions system and a different perspective than the individual team members who are rightly focused on their cases and their clients. And what I see is a system that has some of the highest profile criminal defendants in American history, but can't manage to bring those defendants to a fair trial. I see a group of defense attorneys who work within this system who provide an example to all of us what it means to be a successful trial lawyer. It is their work defending the rule of law for all of us that has exposed the Guantanamo Bay military commissions as a failed experiment. And considering the gravity and importance of these cases, that failure is one that hurts us all. This failed experiment comes in the worst possible package. First, these are major cases, incredibly complex, held years after the events in question, involving massive amounts of information. The charge sheet in the 9/11 case, for example, alleges almost 3,000 victims and criminal acts in 14 countries. According to the FBI's website, at least 30 of its foreign officers were involved in the investigation, using over 4,000 special agents and 3,000 professional employees, responding to more than 500,000 investigative leads, conducting more than 167,000 interviews, and collecting more than 150,000 pieces of evidence. And much of this information is classified. Questions about the law and its application in these cases would be enormously complex in an established justice system. And ours is anything but an established justice system. Second, most of these cases are capital, and if found guilty, the accused may be sentenced to death. Our well-established court-martial system, of which I am normally a huge fan, has demonstrated an inability to handle death cases. Indeed, the court-martial process has an 80% reversal rate in death cases. If that system, with its well-defined rules and even playing field, is ill-equipped to handle capital cases, the commission system, where a judge has marched a case forward for several months, despite the accused not having a lawyer present with any death penalty experience, has no business handling capital cases. More simply, the due process our nation has determined necessary for a capital case exceeds the due process our nation is willing to afford commission's detainees. Third, and this touches upon everything, the United States chose to secretly detain and torture the men it now seeks to execute. Justice was an afterthought. As a CIA interrogator told a detainee, "You will never go to court because we can never let the world know what I have done to you." The legal ramifications of the secret detention affects these commissions in so many ways, driven by what I see as the U.S. government's manifest interest in keeping torture out of these trials. The chief prosecutor who was serving a decade ago when the CIA's high-value detainees arrived at Gitmo has since said, rather than bolstering the prosecution's case, allegations of abuse required further investigation and might leave the prosecution in a weaker position. He could not have been more right. Torture impacts every aspect of the litigation of these cases. Indeed, torture's impact on the military commissions continues today. Justice cannot be done without a full accounting of these events, commensurate with the requirements of any capital case. And the system will not be fundamentally fair unless and until it exposes and reckons with, at least in our capital cases, with the extreme nature of the government's misconduct. Indeed, the military commissions may well be the only way America has left to attain any accountability for the torture performed in our name a decade ago. These issues, particularly the effects of torture, would cripple any normal any normal case. But they are layered on top of so many other problems embedded in this failed experiment that we call the Guantanamo Military Commissions. I'd like to turn to those now. I am frequently asked why these trials take so long. For many, delay is the biggest concern. Delay is a huge problem. Some of the students here will graduate in 2020, 2 decades after the USS Cole's bombing, for which one of the McDowell's clients is still awaiting trial. But the delay that leaves us in April 2018 with no trial date in sight is a byproduct of problems that are more fundamental, with the potential to reach far beyond these cases, both as precedent and by corrupting our core principles. So where are these military commissions today, more than 16 years from 9/11, and with not a single case that has been referred under the 2009 Military Commissions Act having been reviewed on appeal? I'm going to answer that by explaining what's happened since January, because some events that we have dealt with since the beginning of this year demonstrate at varying levels why the Guantanamo Bay Military Commissions are a failed experiment that hurts us all. And not coincidentally, these same events shine a light on why lawyering matters and what it truly means to be a trial advocate and a defender of the rule of law. First, in January, in a stark reversal of the government's position stated on the record in 2013, the chief prosecutor explicitly threatened my defense attorneys with the possibility of criminal prosecution if they continued to engage in their independent investigations overseas. Let me repeat that. The chief prosecutor explicitly threatened my defense attorneys with the possibility of criminal prosecution if they continue to engage in their independent investigations overseas. Their attempts stateside to try to speak to the people who know about their clients' torture led to this same threat of prosecution. And when the defense protested and said, hey, these are capital cases, we need to do a thorough investigation, the prosecution told the judge that the defense had no right to, quote, investigate. Later, the government tried to put a good face on the situation, saying they weren't really threatening prosecution at all. But they still took the position that an intelligence agency should approve the defense proposed questions to torture witnesses just in case the defense steps out of line. Keep in mind that, according to the Senate torture report, the events the defense is trying to investigate happened a decade and a half ago. And my defense counsel had the same security clearances as the prosecutors. But someone has determined that despite these clearances, and these being capital cases, that my defense counsel do not need to know the information they are seeking about their client's treatment in confinement. In fact, recently the government insinuated that continuing to investigate torture was a, quote, waste of time, or cumulative, or my personal favorite, not relevant to the actual facts at issue. Then, in early February, the convening authority was fired along with his chief legal and policy advisor. The convening authority is the DoD civilian who oversees the military commissions and is responsible for, among other things, negotiating plea deals, like the district attorney does in most counties, and making funding decisions on defense expert requests, like many district court judges do in the federal system. A few weeks ago, pursuant to an order from a judge in Guantanamo, Secretary Mattis and his staff submitted an 11-page declaration attempting to justify this decision. But the former convening authority provided a different declaration, explaining that he had no idea why he had suddenly been removed, that he had not been approached or warned about poor performance prior to being fired, and that he was forced to conclude that his firing had something to do with the decisions he made as a convening authority. The why of this firing could affect the legitimacy of these cases because of a military concept called unlawful influence. Unlawful influence is when a commanding officer interferes with a military prosecution. So if Secretary Mattis was influenced by his staff or by others to fire the convening authority because of how he was overseeing the cases, that could be a huge legal problem. Later in February, we learned that Ahmed al-Darbi, who had pled guilty in 2014 and agreed to give testimony in exchange for being released to his home country by February 20th, 2018, had not actually been released as had been promised. Even though the government had agreed to do this 4 years ago, even though they signed a plea agreement stating as much, and even though they agreed in court that Mr. al-Darbi had fulfilled his end of the bargain, Mr. al-Darbi remains confined in Guantanamo. And the government hasn't given any indication beyond cliched platitudes that his release to his home country will actually happen. These situations, the firing of the convening authority, the government's refusal to permit investigation into torture, or to release Mr. al-Darbi despite a written agreement to do so, speak to an ongoing tension between protecting national security and adhering to the rule of law. In order to negotiate that tension, an advocate must be flexible, exercise good judgment, and possess a profound amount of patience. She must be tenacious because her duty is to investigate and develop her client's case, even if the government threatens her for doing so. And she must also be a true patriot. After all, these defense attorneys all swore oaths to defend the Constitution of the United States. Oftentimes, that means taking positions that run contrary to the politics of the day, and in the highly adversarial atmosphere at Guantanamo, it always seems to mean taking a position that the government does not agree with. But her client's life depends on her doing so. And at the end of the day, so does our commitment as a nation to uphold the rule of law. Finally, and I plan to spend some time on this, throughout this year, my defense teams and I have been dealing with the aftermath of the government's continual disregard for the sanctity of the attorney-client relationship. In fact, that's not just an issue that we've been dealing with this year. This is an umbrella issue that has plagued the military commissions almost since the time the clients were first charged. The government's disregard for the sanctity of the attorney-client relationship denies military commissions defendants the right to counsel and sets a dangerous precedent for the American criminal justice system. As you know, criminal defendants are guaranteed the right to effective assistance of counsel. And the right of effective assistance of counsel includes the right of private consultation with counsel. The purpose of the attorney-client privilege, the Supreme Court has said, is to, and I quote, "It is to encourage full and frank communications between attorneys and their clients, and thereby promote broader public interest in the observance of law and administration of justice." Essentially, for any criminal justice system to work, Defendants must have the ability to trust their lawyers and speak with them in confidence. As Buddy Segal surely would agree, if you don't have that, you don't have a legitimate legal system. And the stark and very depressing reality down at Guantanamo is that the defendants have no reason to trust their lawyers or think that they can speak with them in confidence. McDowell lawyers have told their clients that no one will read their privileged materials, that no member of their defense team will violate the attorney-client privilege, and that no one will, quote, unintentionally overhear, end quote, their privileged communications with their attorneys. Yet despite their best efforts, over and over again, when McDowell lawyers tell their clients they can speak frankly, another government intrusion is revealed, and the defense counsels look at best like fools and at worst like liars. Let's go back to 2011 when these cases in this latest iteration of the failed Guantanamo commissions began. Joint Task Force Guantanamo, which is the command responsible for the custody of detainees in Guantanamo, seized, copied, and translated all written materials in detainees' possession. This included very clearly marked documents as attorney-client privileged. And incredibly, this seizure of privileged materials was done after consultation with the Joint Task Force lawyers. The judge who first addressed this search and seizure concluded that it, quote, infringed on the attorney-client privilege. The government promised not to engage in conduct that infringed on the attorney-client privilege, yet similar conduct has continued. Then, in the space of 3 months, beginning in January 2013, the 9/11 defense teams discovered that an intelligence agency could shut down the live courtroom proceedings without the knowledge or assent of the judge, and that same agency had the ability to listen to courtroom conversations through microphones placed on defense tables. Next, in February 2013, one McDowell attorney took it upon himself to climb onto a chair in an attorney-client meeting room in Guantanamo and write down the make and model of what the Joint Task Force guards and one Joint Task Force lawyer had explained to be a smoke detector mounted on the ceiling. With that make and model, the McDowell lawyer returned to his office to Google the company and discovered that the company did not make smoke detectors, but instead made microphones disguised as smoke detectors. These hidden listening devices existed in all attorney-client meeting rooms where commissions defendants met with their defense counsel. When this issue was litigated, the government promised not to utilize such devices to infringe on the attorney-client privilege. As time has passed, we would learn that this was yet another broken promise. Then, on a Sunday in 2014, shortly after church, 2 members of the FBI appeared at the home of a McDowell staff member. After some conversation, what some may call rapport building, the FBI agents asked the McDowell staff member to reveal privileged information about the case he was working on, as well as other pending military commissions cases. The FBI agents were successful in persuading the McDowell staff member to sign a contract to become a confidential informant against the McDowell and provided the government with a treasure trove of privileged materials. We have not even begun to appreciate the fallout of that broken promise, as the litigation surrounding this issue is far from over. Then, during a February 2015 hearing, one of the 9/11 accused announced that he'd recognized his interpreter sitting at his defense tables from one of the black sites where he was interrogated and tortured. This shocking revelation that a government-provided defense interpreter may have been involved in the torture program led to well over a year's delay in the proceedings while hearings were canceled and court-ordered investigations were conducted. And the FBI interpreter, and like the FBI interpreter issue, the litigation on this incident is far from over. I'm going to skip over other incidents and fast forward to last spring. In May of 2017, prosecutors in 2 cases, the al-Nashiri and the Hadi al-Iraqi cases, filed classified notices informing the presiding judges and the defense teams in those cases of certain classified information. As a result of those filings, I recommended to all McDowell defense counsel that they should discontinue attorney-client meetings with their clients until they could, quote, know with certainty that improper monitoring of such meetings is not occurring. In the wacky world of Guantanamo, this essentially means no attorney-client communications at all. other than short, heavily screened letters, because my defense counsel are not permitted telephone communications with their clients at Guantanamo Bay. It's hard to overstate how serious of an issue this is. I, the supervisory attorney with the regulatory responsibility to advise all military commissions defense counsel on the ethical practice of law, had recommended to the defense counsel that they not meet with their clients. Shortly after my recommendation, the government admitted that some attorney-client communications had been, quote, unintentionally overheard at Gitmo, but claimed that none of the active cases were impacted. All of this put counsel in a tremendously difficult situation. Do they meet with their clients in a situation where their supervisor had recommended that they not do so? Or there could be secret monitoring of their conversations with their clients? That might be the only ethical option from the defense counsel's perspective, but in order to stop meeting with a capital client, counsel would have to give him some kind of explanation. And therein lies yet another issue. Many of the facts on which I based my recommendation were classified up until about 3 weeks ago. But defendants at Guantanamo don't have security clearances, so they can't be told classified information. That made some of the defense attorneys fearful of meeting with their clients, lest their conversations be overheard, but they couldn't tell their clients about that fear, since they would risk getting prosecuted for leaking classified information. Finally, last month, the government publicly admitted that there were hidden legacy microphones in the locations where Mr. al-Nashiri, the accused in the USS Cole case, met with his lawyers. And if you remember, in 2013, they said they wouldn't do that again. The Nashiri team discovered one of them in August of last year, but they were told the existence of the hidden microphone was classified. When they asked for a hearing about the issue, the judge denied one. And remember, attorneys can't tell Guantanamo defendants classified information. So even though they asked the judge for special permission to do so, counsel couldn't tell Mr. al-Nashiri that someone had potentially bugged the room where he met with his lawyers, and that no one knew who had done so or whether the microphone still worked or could be made to work. After this, 3 civilian attorneys for Mr. al-Nashiri requested my permission to withdraw from the case due to the ethical situation in which they found themselves. One of those lawyers was Mr. al-Nashiri's learned counsel, the expert in death penalty defense that he is entitled to by law. I granted that permission because I read the law pertaining to the military commissions, which is a separate and distinct body of law from that governing federal court cases or even courts-martial, is giving me the authority to excuse counsel. However, the judge in the Nashiri case disagreed and said that he, as the judge, was the sole authority who could decide who was on a defense team, and ordered me to rescind my excusal. I declined, and he held me in contempt and ordered me to serve a 21-day sentence of confinement. As you heard earlier, that was reduced pretty substantially to 2 days. We could debate the merits of who was right in that situation. In fact, a federal court is deciding that issue right now. But in the meantime, down at Guantanamo, the military judge went ahead with hearings in the case during 3 different months, hearings in which the government sought to introduce evidence into the record, despite no jury having been selected yet, and all while Mr. al-Nashiri did not have a lawyer with him who'd ever tried a murder case, much less a death penalty case. The kicker to all of this is that the Nashiri team only found 1 legacy microphone, but the government's just declassified statement about the matter admitted that more than 1 microphone was removed from the meeting location. The government claims that these microphones were disconnected and inoperable the whole time, but it also removed them, along with the meeting location's, quote, flooring, walls, and fixtures. So that claim cannot be tested. That level of secrecy, which conveniently surrounds this and so many other important aspects of our cases, tells a story of the illegitimacy of the system. How this gets resolved, I honestly don't know. Whether an appellate court will say that the current situation in Guantanamo is untenable, or that it amounts to a denial of the right to counsel, is an open question. But it's one by which the legitimacy of the entire system hangs. Meanwhile, the McDough defense attorneys still have to operate as effective advocates within that system. That demands a ton of resilience. It takes a tremendous amount of fortitude to keep your calm and keep on protecting your client when the government has hidden microphones in your meeting room or is putting an FBI informant on your defense team. It also requires constant attention and devotion to ethical standards. Even more than most, McDough clients can't speak for themselves. They literally have no means of contact with the outside world. They depend entirely on their lawyers to look out for their interests. And so their advocates must always be vigilant for threats to those interests and must protect them, come what may. Last but not least, it demands bravery. A good advocate in this system must speak truths that are difficult to hear, whether about torture or governmental secrecy, or what the rule requires that we give to everyone, even those charged with the crimes McDough clients face. He must speak truth when it is inconvenient and when it is hard, and he must protect his clients when it is scary to do so. If the military commissions are to have a hope of legitimacy, it will come from the advocates who face loss and ridicule and investigation and even jail, but do not waver in their duty. Between the issues and the government's threat of criminal prosecution if defense attorneys continue to locate critical witnesses to torture, the status of the Nashiri case, the firing of the convening authority, and the reignition of the debate about torture, there has been increased press attention given to Guantanamo lately. I am hopeful that even more attention will be given to the commissions in the coming years. We will be sorry if we recognize too late the threat these commissions pose to the rule of law. I want to be the first to acknowledge that while I have many criticisms of the system that is currently structured and implemented, at the end of the day, I don't have a solution. I don't have a way ahead, and I can't tell you how to fix these military commissions. That's not my role. All I can tell you is that the experiment has failed, and I don't know if what remains can be salvaged. What I do know is what happens down at Guantanamo matters. After the passage of the Military Commissions Act, a former chief prosecutor for military commissions stated that his goal for the Guantanamo military commissions was to be remembered by future generations in the same favorable light as the Nuremberg trials are held by members of this generation. The U.S. government, unfortunately, has failed and continues to fail this test. Future generations will look back at these proceedings as a missed opportunity for America to show the world its commitment to justice, human rights, and the rule of law. If the U.S. government still intends to use Nuremberg as its guide, they would be wise to listen to the chief prosecutor at Nuremberg, Justice Robert Jackson, who recognized the danger of powerful nations unilaterally dispensing justice onto a purported enemy. Justice Jackson said at his opening argument at Nuremberg, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. Instead of respecting the Constitution and ensuring equal protection under the law, the U.S. government is choosing to drink from a poisoned chalice. If our government wants the most important criminal cases in American history to be tried by military commissions, it is essential that the proceedings live up to the highest standards of American justice. They have not. Instead, they leave behind a legacy of uncertainty, government misconduct, and torture. This is a gross injustice being done to the individuals charged in the system and the victim family members seeking justice. But it is also more than that. It is, as Justice Jackson recognized, a matter of national security and integrity as well. There is one shining light in all of this. If our nation were once again decide to use military commissions in a future armed conflict, the efforts of our defense teams to attempt to change the poison chalice of Guantanamo into legitimate and credible proceedings lays the groundwork for a system that could fully comport with the rule of law and garner the respect of the international community. In defending the rule of law by fighting for their clients, the advocates at the McDough are defending the rule of law on behalf of all of us. I could not be more grateful and proud to lead this organization. I'm going to end where I should have begun. As it should be obvious by now, I am extremely proud to lead the McDough and to recognize the phenomenal work by the advocates assigned to it. If we as a nation are going to, quote, play the ethical midfield, as Secretary Mattis challenged us to do last summer, the McDowell must continue to be the voice for the rule of law. Our attorneys, paralegals, investigators, security officers, analysts, interpreters, information technology experts, and operations and administrative support personnel all work long hours, spend weeks at a time away from their families, and deal with the daily frustrations and indignities, all in the name of the rule of law, not only in the United States, but around the world. They do this important work because most of them have taken an oath to support and defend the Constitution of the United States against all enemies, foreign and domestic. The attorneys also swore an oath when becoming a member of their own bars. And I'm reminded of the state oath of one of our attorneys, which reads, "I will never reject, from any consideration personal to myself, the cause of the defenseless." It is with that attitude that the McDowell attorneys approach every day. That is the mark of a true advocate. I'll close here so that you may hear from one of those true advocates, Ms. Alka Pradhan, who, as you heard, is the human rights lawyer for Ammar al-Baluchi, one of the 9/11 co-accused who is facing the death penalty down at Guantanamo. You heard from Dean Ruger, Alka's impressive bio. So, Alka, the floor is yours.
Thank you. Thank you very much. And I'm going to speak briefly just to augment some of what General Baker was saying. But first I want to say thank you to Dean Ruger, to the Penn community, to Dr. Segal for being here. And thank you so much to General Baker for the kind words. I'm used to being called a lot of things, especially in this line of work. But when a general, a Marine general at that, calls you a patriot, you must be doing something right. So it's obviously a great honor to be here at Penn, where I've had the pleasure of teaching some of the brightest students from all backgrounds for several years now. And it's also both intimidating and a privilege to be sharing any part of this stage with General Baker, who has been the most ferocious advocate that Military Commission Defense Counsel could possibly have asked for, and has set such an example of dignity, dedication, and leadership in the face of incredible challenges, as you've heard. And today he's done the hard work in framing those challenges for you. So let me now tell you what it's like representing Ammar al-Baluchi in this chaos. Let me tell you his story. Ammar is a 40-year-old Pakistani citizen who grew up in the Middle East. He is a surprisingly excellent Guantanamo chef. He's an evocative artist. He's a fan of some questionable sci-fi TV series. And he's also alleged to have been one of several people who moved money to the 9/11 hijackers. As a result of those allegations, he faces the death penalty at Guantanamo. He's also a torture victim, a fact that has been admitted by the US government. Torture is, as you just heard from General Baker, is the nasty center of Guantanamo, of the 9/11 case, and almost all post-9/11 counterterrorism operations. General Baker told you that the prosecution recently enacted prohibitions on our investigations into the CIA torture program. And the government shockingly maintains that such investigation isn't necessary because it's not material to the case. Not only are they wrong, and I'd like to say hello to any of members of the prosecution who are watching the live stream today. I gave them a heads up on Twitter. But the entire military commission system is built around the continued cover-up of state-sponsored torture. Here's what that means for Ammar. Ammar was arrested in 2003 in Pakistan. Shortly thereafter, he entered CIA custody and was rendered to the infamous black sites, the secret prisons around the world that were designed for incommunicado detention of these men. We now know, and these facts were included in a transcript released by the government marked for public release last week, that CIA officials and FBI officials were present in Pakistan during Ammar's initial detention and interrogations there. The Senate Intelligence Committee report that was released in 2014 also describes how the FBI used information obtained from the black sites by the CIA, information gained through torture. I should pause here and say that obviously nothing I say ever reflects the opinion of the Department of Defense. and nothing I say should be taken to confirm or deny information that the government considers to be classified. We've had this vetted. So information gained from torture is being used by the FBI and the CIA, right, stemming from these interrogations at the black sites. What kind of torture? For those of you who have seen Zero Dark 30, it's a terrible film, that detainee being tortured for the first 20 minutes of the movie is my client. That is Amar. His name is even Amar in the movie. They didn't bother to change his name. That character depicts some of what happened to Amar at the black sites. Unclassified records of his torture document how he was subjected to, and I'll read from an unclassified transcript here, among other things, walling, stress position standing with forehead against the wall, stress position on knees with back inclined towards feet, water dousing, and cramped confinement if deemed necessary. Sleep deprivation in excess of 72 hours was also approved, and we know that Amar was at one point subjected to sleep deprivation standing for 86 hours while shackled. Amar was subjected to variations of these techniques for 3.5 years and continuously interrogated that entire time until he and the other so-called high-value detainees were brought to Guantanamo in September 2006. So what happened then? They remained under CIA control, without lawyers or any access to the outside world. Then in January 2007, they were reinterrogated by the FBI in what the government calls, richly, the clean team interrogations. Under the best of circumstances, their answers at that point would have been the products of years of torture. But to add to that mental state, the FBI agents who interrogated them recently admitted to using CIA black site documents to prepare for those so-called clean team interrogations. So the documents we are given as defense counsel from the black sites are stripped of torture information. They just list in conclusory fashion the things, the bits of information that Amar is alleged to have said to his interrogators. It's only when we investigate, when we conduct an independent investigation of the torture program and put his interrogations together with that other information that you realize the full horror of what was happening. That any information that was coming out of Amar's mouth was, for example, after 86 hours of prolonged shackled standing with his arms above his head. During violent interrogations in cold rooms described by interrogators as dungeons, while nude. So those FBI statements from 2007, again, the product of years of torture, are what the United States wants to use as primary evidence in the biggest criminal trial in US history. Uncovering the full relationship between the agencies during his detention, the full details of his treatment over those years and how it affected those statements, therefore, is one of our biggest challenges as his attorneys. Another is battling the government on how much of it we can do in public. The government doesn't want you to know any of this. Every bit of information I just gave you was wrestled from government classification over the course of 10 years now, more than 10 years since they've been brought to Guantanamo Bay. That's why the trial is in an opaque military commission at Guantanamo Bay, where you need to be cleared to visit and jump through 1,000 hoops. It's why there is no publicly available feed of even the open sessions of the hearings. It's why I'm prevented from sharing with you even many of Amar's unclassified memories of his torture. It's why the government never talks about Section 948R of the Military Commissions Act, which allows for the use of coerced evidence in prosecution, which is meant to encompass those clean team statements. It's why they've now stopped public display of even his artwork, which federal death row prisoners are able to do. And it's why they continually criticize the Twitter feeds of those who document Guantanamo proceedings and developments. And so I should direct you, first of all, to Carol Rosenberg of the Miami Herald, Gitmo Watch. I have a feed. Multiple defense attorneys have feeds, and I encourage you to follow them all. The government wants you to think of Ammar as a subhuman monster, someone without human feelings, so that they can continue to quietly withhold his human rights and the American public won't care. But he's not. And you have a right to know all of this. He's a 40-year-old man, a torture victim, with a legal team who spend every day trying to save his life. Not just through the litigation. Ammar has deteriorated significantly from his years of torture, such that he has real physical and cognitive limitations that we have to try to assist him with in getting him medical care, which is not easy at Guantanamo. And come up with therapies he can do himself in essentially solitary confinement at Camp 7 at Guantanamo. And that brings me to my final point. It is possible to do many jobs solely because they are the right thing to do, especially as a lawyer, right? You get used to, I was in private practice, you get used to defending people or entities or corporations that are despised, and you don't have to like them, right? It doesn't matter. You defend them because it's the right thing to do, because everyone deserves representation in our justice system. I posit to you that you can't do that here. The Defense Council of the Military Commissions Defense Organization don't do it solely because it's the right thing to do. Because of the extent to which these men have been dehumanized and forgotten by much of the world, in order to represent Ammar, we have to really, really care about him. We have to make sure we're not, I'm representing him, not just making some great legal argument, but being sensitive to his background, to his humiliation and torture at the black sites, that we're deferring to him as much as possible on decisions that could impact whether he lives on or dies. Because that also affects his life now, right? Knowing that I and my team care about what can help him sleep better this week because he's so sleep deprived after his years of sleep deprivation at the black sites. That's what being an advocate means in this situation. Finding the right foods for Ramadan, which is coming up, that are similar to what he ate in his childhood in Kuwait. That's what being an advocate means here. Filing a 300-page motion, which I just did this morning, a little sleep deprived myself, to show him to allow him to show his artwork publicly, because it reminds him and the public that he is still a human being. That's what being an advocate means, right? Treating him like a human being. And it means being angry every minute of every day about the impunity with which our country has acted and continues to act. We have to try to right the wrongs that we know for a fact were visited upon Ammar by the government, and separate those, as justice demands, right, from the yet unproven allegations that have been pending for 15 years. We have to. That's part of what due process means. And in the very emotional, understandably emotional context of September 11th, most people dislike you most of the time for it. Whether we win or lose, and the deck is, as you've heard, stacked pretty heavily against us, this is the most important work I may ever do. And we want you, the public, legal scholars, future lawyers especially, and I see some of my students here, automatic A's. We want you to know what is happening in your name so that you can help stop it, right? You can do that by following the Military Commission's developments, by taking a week and coming down to Guantanamo as an observer, and by helping to amplify the continuing violations that are being perpetrated at Guantanamo. And you're doing it by being here tonight, and for that I thank you. So thank you.
Well, I want to deeply thank both speakers, both for your inspiring and interesting words and for the work that you do, which is so important. I know the audience was as interested as I was hearing you both talk. You've graciously agreed to take a few minutes for any questions we have, and I think there's, for those in the audience, there's 1 or 2 microphones, and so I'd invite, we can take 5 or 10 minutes for a few questions before heading upstairs for the reception. Yes?
So, thank you very much, General Baker and Mrs. Pradhan. I think that the main question that is kind of on everybody's mind after hearing all of this is that who will judge the judges? Who will prosecute the prosecutors? Who will enforce the law on the cops? And who will discipline the soldiers? Because law and legal ethics and the Constitution and human rights exist independently of anyone who is supposed to enforce them. And when the people who are supposed to enforce them do not enforce them or enforce things that are antithetical to them, so that is when these questions arise on a kind of a historical magnitude. So the question I have, General Baker, is do you think that on the chain of judging the judges, do you see kind of a light at the end of the tunnel, whether it's the US Supreme Court or any other kind of legal, moral, ethical force that's supposed to operate here? Thank you.
Boy, that's a hard question. I'm not going to answer the who will judge the judges. I think that one group of judges is going to be history. That what happens down at Guantanamo Bay is going to be judged by history. I mean, there certainly is an appellate process. And let me tell you, that process is scary. I'll tell you why that process is scary. We have 6 capital cases. The first level of review of our 6 capital cases is the commission. I always forget what CMCR stands for. Commissions. It's our first level of review. Filled by military appellate lawyers, or excuse me, military appellate judges, and some civilian practitioners, not one of whom has ever tried a capital case. That case will then be reviewed by the DC Circuit Court of Appeals, who has not, in the memory of anybody who's ever worked for me, ever reviewed a capital case. And in the 9/11 case is being judged by a judge who's never judged a capital case. But having said all that, I am a humongous believer in this system, in that somebody in some level of review is going to look at this and say, what the hell is that? And I also want to be clear, I don't think, and this may be the minority position of where I work, I don't think people are doing this because they're trying to do the wrong thing. I just think that they just have lost their way. Again, I think it's a minority position. But I don't know. You've asked me a hard question. Do you have a better answer?
Better answer, sir. I have a more contentious answer, probably. No, I think, look, I think it's up to all of us to judge this, right? No one, as a practical matter, the Supreme Court and all of the actual federal courts, like real courts, have basically washed their hands of Guantanamo, right? We had 2 cases up on cert before the Supreme Court last year, and the Supreme Court denied both of them, right? One of them completely unjustified. And so nobody wants to deal with this system because it has turned into a beast of its own making. So no one's going to judge it, let's be honest. The only judgment that's going to come is from the public. That would be my answer. And I agree with General Baker that I don't think anyone's deliberately trying to do the wrong thing. But I think that this is, as I said, I think that this has turned into a situation where the cover-up has become the point of the whole thing. The entire system has been built around the cover-up, and we've lost sight of any sense of justice in these proceedings.
Thank you for your hard work and courage.
Professor Pradhan invoked the important term impunity in the closing part of her remarks. And I'd like to ask both of you, and General Baker, this may or may not be a question that you feel you can address, but I want to hear from both of you if you can. The Obama administration made a decision not to pursue criminal investigation and prosecution of those who had perpetrated torture in the prior administration. or under the watch of the prior administration. And to what extent does that decision carry a legacy forward into the atmosphere of impunity that surrounds, as Professor Pradhan puts it, the covering up of this prior torture and the shaping of this system around the existence of a record of torture that has never been held to account through the criminal process?
Man, I don't know. I think that there's been a lot of policy decisions. Certainly we're going to look forward and not backwards has caused unforeseen consequences. There seems to be little holding people accountable for actions that they have made. But I'm a military guy, and the cool thing about being a military guy is policy decisions are for policymakers. They tell us what direction to go, and we generally go in that direction. We may argue about it, so I'm going to kind of punt, but there is a level in any court proceeding. Both sides are righteously indignant all the time, although nothing to the magnitude. But there is a lot of I get the sense that there is a lot of people thinking they've done the right thing, and people wanted to put this in the rearview mirror. The problem with wanting to put this in the rearview mirror is there is a due process requirement in our cases to look backwards. The first capital case that I did involved a guy who it was a retrial, so he spent 15 years on death row. My entire case was his time on death row. That's really all I had. There was really no question about what had happened. That's what they want to do. They want to build part of their mitigation case about what happened to their clients in confinement. That's kind of a tangent. You have
One comment.
Okay.
I see my students snickering. No, I as you could probably imagine, I think that President Obama's decision not to take action, frankly, and hold people accountable for what happened, particularly at the CIA black sites, but all over, right? Post 9/11 was a huge mistake, and I think is part of the reason why we are in the situation that we're in. I will tell you very briefly that for a very long time in litigation at the Military Commission, and the general position of the government is to sort of treat in soft focus torture issues. They don't deny torture occurred. They basically say over and over again, yeah, we're not going to argue about that. It's not relevant. It's not material. We're not using evidence from it, which is not the case, but you see what I'm saying. That the decision to not hold anyone accountable has allowed them now, right, in a very different political atmosphere where torture is suddenly being debated again, which is infuriating, to come out a little bit on that. The very first hearing we had at the end of 2016, following the election and following a great deal of rhetoric about whether or not waterboarding was torture, my goodness, after so long, one of the prosecutors for the very first time stood up in court and said, you know what, doesn't matter what the CIA did, I know that we were safer for it, and I'm grateful to them. Okay? Now that's something we never heard before from the prosecution. The government's usually very careful about not making statements like that because you understand, I think most of you understand how that comes off. So that we've heard more of in the past, say, year and a half or so. And I think that is a direct consequence of not dealing with it. And that's one very minor consequence. There are others.
General, Professor, thank you very much. Thank you, first of all, for your presentations and much more for your service to the country and making us proud to be Americans. What can we do proactively to help?
One is pay attention. So, in the hearing with which I was held in contempt, there was a single reporter there. One reporter. People found out about what occurred from a Twitter feed. I completely get why people really have, when I took my job, someone told me people have Gitmo fatigue, because the story hasn't changed. It's just madness down there. But if we don't pay attention, you could talk to your representatives about fixing the process. What do you got? No, I mean, it's pay attention to what's going down there.
I think that's largely, just remember that we're making bad law down there every day, right? Not just on constitutional issues, but on really important international law issues, right? We had argument last year about whether 3 of the charges are actually war crimes, right? It has to be a war crime to charge it at a military commission, otherwise you can't have a military commission. Things like that establish really terrible precedents, particularly when it's the United States doing it. So we're setting awful examples, and what happens at Guantanamo Bay is really not all that far from what's going to happen on the mainland.
Thank you.
One more question.
Tangential question. As a preface, I used to be an Army Special Victim Prosecutor and operational law attorney. It's for General Baker. You mentioned your appreciation of due process in courts martial, et cetera. My question, given your concern, and I commend you for ensuring due process to purported terrorists, do you still have that same level of confidence in the court martial system given the revisions of the UCMJ under the Me Too movement, and how do you see your confidence in the UCMJ moving forward?
So, to get a little bit of context, since 2012, there have been, I used to know the right number. There have been a gazillion, let's put it that way. There's been a gazillion changes to the Uniform Code of Military Justice. Some of those changes were good and some were not so good. Do I still believe in the UCMJ? Yes. I believe in the advocates that work in the system. I believe in the prosecutors that are prosecuting, the defense counsel that are defending, and the judges that are overseeing. And there's a third advocate in the courtroom, in the court-martial system. That's a victim advocate. I was staunchly against the providing an advocate to a victim in court until I saw it play out, and I've become a fan of it. So no, I still think the UCMJ provides the best justice system that we have. I think it's better than the one here in Pennsylvania. So I would still remain a big fan.